Senyor conseller del Consell de Garanties Estatutàries, senyor diputat, senyor director de Drets i Afers Constitucionals, senyores i senyors, bon dia. En nom de l'Institut d'Estudis de l'Autogovern us dono la benvinguda i agraeixo l'assistència a aquesta jornada sobre el recurs d'inconstitucionalitat i la legitimació de les comunitats autònomes. Aquest agraïment, a banda de vostès, també va per a l'equip de l'Institut, que fa possible jornades com aquesta, i per descomptat dono les gràcies a les persones que presentaran avui les seves ponències, que tindran elles el protagonisme avui. Gràcies, thank you very much. Entre les persones a les que cal donar les gràcies, encara que avui arribi una mica més tard, vull destacar Mario Kelling, que representarà aquí la Fundación Manuel Giménez Abad. Aquesta és l'entitat que organitza amb nosaltres aquest acte. Per nosaltres aquesta circumstància és especialment significativa perquè recordem un amic comú d'alguns de nosaltres, Pepe Tudela, amb qui aquesta jornada va ser preparada i que ens va deixar fa poc d'una manera tan trista com sobtada. Esperem que el seu rigor intel·lectual i esperit de diàleg ens continuïn inspirant. Aquesta jornada té el títol que ja coneixen i que destaca el paper que poden tenir les comunitats autònomes en defensa de la supremacia de la Constitució. Com saben vostès, la llei orgànica del Tribunal Constitucional imposa una restricció de dubtosa constitucionalitat. Deixin-me dir-ho. Intentaré explicar-me. La Constitució posa en peu d'igualtat els executius autonòmics i diu, en el seu cas, les assemblees autonòmiques, amb la resta d'actors legitimats per interposar un recurs d'inconstitucionalitat. Però, per la seva banda, l'article 32.2 de la Llei Orgànica del Tribunal Constitucional exclou tant els executius com les assemblees de les comunitats autònomes de la possibilitat de presentar recursos d'inconstitucionalitat per cap altre motiu que no sigui el de l'afectació del seu propi àmbit d'autogovern. La literalitat del text constitucional només permetia restringir la legitimació de les assemblees autonòmiques. Recordin, la fórmula, en el seu cas, només es refereix a les assemblees autonòmiques i no als seus òrgans executius. La llei orgànica del Tribunal Constitucional, per donar una referència més o menys paral·lela, no restringeix al defensor del poble la facultat de presentar recursos d'inconstitucionalitat a allò que afecti els drets fonamentals. I malgrat tot això, hem vist com el Tribunal Constitucional ha admès recursos originats en comunitats autònomes referits a qüestions que difícilment encaixen en les seves competències, com ara la llei d'amnistia. Només per això ja val la pena que pensem en qui té realment la legitimació per a presentar recursos d'inconstitucionalitat. A més, i potser és encara més important, la qüestió va més enllà d'allò merament processal. Es tracta de saber si en un estat compost les unitats que el conformen poden defensar la supremacia de la Constitució en qualsevol àmbit, com fan altres actors. Segur que les aportacions de la professora Villino i del professor Carrillo ens ajudaran molt, però també ho faran les ponències de les professores Arban i Sahadžić. La dinàmica del funcionament dels estats federals comporta la regulació dels conflictes i l'existència d'un tribunal que els resolgui. L'accés dels ens subestatals a aquests tribunals i el paper que tenen en la seva configuració ens donen la dimensió comparada que ens permet emmarcar i així comprendre millor els nostres problemes. Espero que gaudeixin de la jornada. Ara els deixo amb Mireia Grau, responsable de l'àrea d'investigació de l'Institut, que moderarà la primera part de la jornada. Després de la pausa cafè serà Gerard Martín, cap de l'àrea d'assessorament, qui farà aquesta tasca. Claurà l'acte el professor Mario Kelling en nom de la Fundación Manuel Giménez Abad. Gràcies de nou.
D'acord, bon dia. Good morning, Maja, Erika. It's a pleasure to have you here after all our international adventures, finally, in Barcelona. Els hi presentaré les dues ponents. Erika Arban és investigadora i docent especialitzada en dret constitucional comparat i teoria de l'Estat. Les seves recerques se centren en federalisme, autonomia territorial i govern multinivell. Ha publicat en revistes internacionals i participa molt sovint en debats acadèmics sobre governança democràtica, sempre aportant una perspectiva crítica i interdisciplinària al dret públic contemporani. Maja Sahadžić és acadèmica en dret constitucional i estudis europeus, amb especial interès en democràcia, drets fonamentals i governança multinivell. La seva trajectòria inclou recerca comparada i assessorament institucional, ha contribuït en diversos projectes internacionals i ha publicat regularment sobre ciutadania, participació política i transformacions constitucionals a Europa. Cadascuna de les vostres intervencions serà de 30 minuts. Si pot ser una mica menys, millor, perquè anem, com sempre, menjant-nos el temps. Per tant, comencem amb Erika. So, the floor is yours.
Okay, there we go. Good morning everybody, and thank you so much for the very kind introduction, but especially for the invitation to be here today. Thank you, Professor Arbós Marina. Thank you to Mireia. It is an honor and a pleasure to be here in Barcelona today. So, the topic of my presentation is the role of constituent units in the appointment of constitutional and Supreme Court judges in federal systems. But before delving a little bit more into this topic with some specific case studies, let me begin with a preliminary question. Why are we interested in this topic? Why does this topic matter? I think there are at least two reasons. The first is perhaps more an academic or theoretical reason. The involvement of constituent units in the appointment of judges in constitutional and Supreme Courts can be a measure or an expression of what scholarship refers to as a shared role. In other words, the involvement of constituent units in decision-making at central level, which is opposed to the self-rule which measures autonomy of constituent units. So, in an ideal federal system, we should have a balance of autonomy and participation of constituent units at central level. We can go back to this point later on. But the other reason why we are interested in this topic is a more practical one. And it goes to the importance that federalism-related disputes have in a federal system. Federalism-related disputes are almost inevitable in any federation. And they usually take two forms. They can be conflicts of attribution, so which level of government is responsible for what, especially when it comes to division of powers. And the other dispute is judicial review. In other words, whether a law passed by either the federal government or the constituent units is constitutional, complies with the Constitution. And these conflicts are very common. And normally, to settle such conflicts, most constitutions, most federal systems resort to courts, to Supreme Court and constitutional courts, who display this role as umpires, as adjudicators, as arbiters of this type of disputes. Although there is a debate ongoing on whether perhaps other forms should be pursued, perhaps non-judicial forms of settling disputes should be pursued. And again, we can discuss this later if we want. But by deciding on such important federalism-related matters, courts may shape the direction of a federal system in a more centralist or in a more decentralist or centrifugal sense. So, in light of this, there is an expectation, or at least it would be desirable, that constituent units participate in judicial appointment because judicial decisions may directly impact regional interests. Furthermore, a unilateral appointment process, so judges that are appointed just by one level of government, may be seen as a potential infringement of the federative principle. And also, a Supreme or a Constitutional Court whose members are appointed unilaterally may not be perceived to be as an independent institution as we may wish. Finally, proportionality in court composition may be particularly important in federations that are characterized by the presence of different linguistic, cultural, or ethnic groups. So, for my presentation today, we will look at several federations, and we will see what are the most common ways for judicial appointment and the degree of involvement of constituent units. And as a very preliminary conclusion, an anticipation of my conclusion, we will see that a direct participation of constituent units in judicial appointment is very rare. So, I have divided the cases that we're going to see in three groups. The first group is when judicial appointment happens with the involvement of the president of the country with the ratification of the Senate. And there are also variations on this theme. And we start with the United States, as the oldest federation and the federation that invented modern federalism. In the US Constitution, we have a clause that is called the Advice and Consent Clause, which basically establishes that it is the President of the United States that nominates and appoints judges of the Supreme Court by and with the advice and consent of the Senate. So the states, the constituent units here, participate indirectly via the Senate. The Senate represents the 50 states, 2 senators for each of the states, and this was considered by the founding fathers as the federal element, the element that allowed constituent units to participate in this appointment process. However, in fact, although this process is federal on the surface, in practice, it works mainly as a political process, not so much as a federal process. In other words, most of the appointments are made following party politics. Presidents tend to appoint judges who are in line with his political views. So, not so much of a federal process. The next federation that we're going to see is Brazil, and here the appointment process is very similar to the United States. So according to the Brazilian constitution, the members of the Supreme Federal Tribunal are appointed by the president with the approval of the Federal Senate. Here, there is another problem in the sense that even if the process is federal on the surface, in fact, most of the judges that are appointed to the Supreme Federal Tribunal come from the 3 wealthiest states of Brazil, São Paulo, Minas Gerais, and Rio de Janeiro. There is very little representation of the states, if at all, of the states in the north. So again, the process here is federal on the surface, but in practice, it is not really that. Mexico is the next example. The Mexican appointment system follows a variation of the US advice and consent clause. The actors, the protagonists are the same, the Senate and the President, but the roles are a little bit inverted because it is the Senate, so again, the organ that represents the constituent units, that has the exclusive power to appoint the Supreme Court judges. upon a proposal made by the President. So the President makes the proposal and the Senate approves. Here in Mexico, it seems that the appointment process is less linked to political ties. So judges are appointed mainly based on their prestige as former judges or as academics or lawyers. So it's less political and more based on merit, but again, not so much on regional interests. Austria, I'll go quickly with Austria. The composition of the Supreme Court, the Constitutional Court of Austria, is a little bit more complex. We have the President, the Vice President, 12 full members and 6 substitute members. And basically, let's just go to the last point of the constitutional provision. The Federal Council, which is the equivalent, the Austrian equivalent of the Senate, the branch of government that represents the Länder, they are entitled, the Federal Council is entitled to appoint 3 members of the 12 that compose the bench and 1 substitute member. The others are appointed by other organs. So again, here the Federal Council, the Senate equivalent, the Länder, can nominate 3 full members and 1 substitute member, but again, the appointment is not related necessarily to regional interests, but decision-making is dominated by party politics. So once again, it is party politics that play a major role. An interesting case is also Nigeria. Here, I consider Nigeria a variation on the theme, and I want to mention Nigeria because it's a federation that is very diverse in terms of ethno-linguistic, religious composition. And here we still have the President and the Senate that participate in the appointment process, but we also have a third body, which is this National Judicial Council. So again, the President appoints members of the court. The confirmation of the appointment is made by the Senate, but the recommendation is from the National Judicial Council, which is this body that is composed of members of the legal profession. Now, I want to mention also one specific feature of Nigeria. So Nigeria is, as I said, a very diverse country, and in the Constitution, they introduced at some point the so-called federal character principle. The federal character principle mandates that basically members of the government, the composition of the government and government agencies, and the way affairs are conducted in Nigeria should reflect the federal character of the country, which means that there should be no predominance of a few states or a few ethnic groups in the functioning of the government, but the government should reflect the diversity of the country as a whole. And this as a way to promote also national unity and national loyalty. And we will go back to this idea of national loyalty later with Maja's presentation. So in a way, the composition of the Supreme Court of Nigeria should also reflect this federal character. So by constitution, the composition of the court shall reflect the diversity and should not feature judges coming just from specific ethnic groups or specific regions. South Africa follows a very similar pattern, presidential appointment after consultation with a judicial service commission and also leaders of the political parties. So here there is no involvement, not even filtered, of the constituent units. It's a decision that is made by the president, by leaders of the parties, and by the commission. But here too, in the South African constitution, we have this cooperative government principle, which basically mandates, among other things, it basically mandates that if there are conflicts, especially conflicts of attribution between the different levels of governments, these conflicts should be dealt with first politically or by way of mediation, negotiation, and then if this does not work, only eventually go in front of a court. Finally, as part of this first group, I mentioned India. India, again, a very large federation, a very diverse federation, but here, again, no involvement at all of the constituent units in the judicial appointment. The appointment is done by the President on the recommendation of the National Judicial Appointment Commission, which is basically composed of members, mostly of members of the Supreme Court of India. But in a string of decisions that the Supreme Court of India released between the early 80s and the late 90s, they basically took over for themselves the role of judicial appointment. So in other words, the members of the Supreme Court of India are self-appointed by the court itself. The President still plays this role of officializing the appointment, but the decision, the actual decision, is made by the court itself. So no participation and no involvement of constituent units. The second group that I'm going to talk about is a judicial appointment made by the federal government, and again, variations thereof. It is true that some of the federations that I'm going to mention and that I have already mentioned, sometimes it's difficult to fit them into the first or the second group, so there could be a debate, but this is the way I organize them. And I will start with Canada, and I think that Canada, as an example, is very useful for Spain because, as you know, in Canada, there is this strong presence of Quebec and the French-speaking province of Quebec with their own civil law tradition. So, in Canada, the appointment of the justices to the Supreme Court is done, in fact, just by the Prime Minister. So it is the Prime Minister, with the assistance of the Minister of Justice, who exercises plenary powers in the selection of Supreme Court justices. In doing so, they consult with leading jurists, with lawyers, with judges from the different provinces, but in fact, there is no formal role for subnational entities, for Canadian provinces, in appointing members of the Supreme Court. However, by law, the Supreme Court Act of 1985, by law, 3 of the 9 justices of the Supreme Court of Canada have to come from Quebec, in light of the French-speaking and civil law tradition of this province. And then by convention, by constitutional convention, 3 other justices have to come from Ontario, 2 have to come from the Atlantic provinces, and 1 from the Western provinces. So this means that there is some regional representation in the court. The justices have to come from different regions of Canada, but in fact there is no direct involvement of provinces in making this appointment. A very similar process is also followed by Australia. Again, Australia is a less diverse federation. So we don't have a strong minority in Australia like we have in Canada, but similarly to Canada, the justices of the High Court are appointed by the Governor-General in Council, which basically means that it is the Attorney General of Australia who consults with the state Attorney Generals, and then he proposes a name to the Prime Minister, and then the Prime Minister asks the Governor-General to formally appoint. But again, it's a federal-only type of appointment with no involvement of constituent units. And in fact, similarly to what we saw also in Brazil, most of the judges in the High Court of Australia come from New South Wales and Victoria, so the wealthiest and most populated states. Belgium, again, we will have a chance to talk more about the working and the functioning of the Constitutional Court of Belgium with Maja's presentation. Belgium is also an interesting case for Spain. As we know, Belgium is almost equally divided. It's almost split in half between the Dutch-speaking north and the French-speaking south. So the composition of the Supreme Court, the Constitutional Court of Belgium, reflects this federal structure of the state. So the appointment of Constitutional Court justices is made by the King from a list of candidates that is presented by the House and the Senate. But what is interesting is that of the 12 justices, 6 have to be Dutch-speaking and 6 have to be French-speaking. So the court shall ensure this diversity of the country. And 6 of them have to be politicians, so judges, politicians, and 6 have to be judges, lawyers. So the court, in this sense, is very symmetrical, both in the language composition and also in the background of the judges. And again, with Maja, we can go more in detail into the actual functioning of Belgium. But in a way, this is possible because of the nature of the Belgian Federation. As I said, it's almost split in two. Switzerland is also potentially another interesting case for Spain to look at, because it's very diverse with Italian, French, and German-speaking cantons. But here too, the role of cantons is limited in the appointment of the judges of the Supreme Court. They participate in the judicial appointment through the Council of States, which is basically the Senate equivalent, but in fact the appointment is mainly political. It is almost impossible to be elected as a judge in Switzerland without the support of a political party. It is true that also the language composition of the court reflects the language of the cantons, in the sense that there are about 3 judges who are Italian speakers, 14 French speakers, 23 German speakers. It is true that they try to maintain also a certain balance in terms of gender and everything else, but the role of cantons basically is very, very limited in the appointment process. Germany potentially is an interesting case. The 16 members of the court, the Bundesverfassungsgericht, are appointed half by the Bundestag and half by the Bundesrat. So half by the federal parliament and half by the Länders parliament, the Senate equivalent. So the Länder participate through the Bundesrat in this appointment process, but again, here in Germany too, regional interests do not play a major role in the judicial appointment. It is party politics that plays the most obvious role. So it is the 2 major parties, the 2 major German parties, the CDU and the SPD, that typically negotiate and decide who is going to sit on the Bundesverfassungsgericht. The third group, I included a couple of examples that was difficult to fit into the 2 previous groups. So the first is Bosnia, and again, with Maja, we will go more into the actual functioning of the court. So Bosnia and Herzegovina, again, is a very diverse country. The constitution specifically indicates that Bosnia and Herzegovina is based on 3 equal constituent peoples, the Bosniaks, the Serbs, and the Croats. The federation itself is composed of 2 self-governing entities, the Federation of Bosnia and Herzegovina, and the Republika Srpska. So Bosnia and Herzegovina, mainly Bosnian Croats, and Republika Srpska, mainly Serbs. And then there is also an autonomous district, the Brčko district. I don't know if I have pronounced it correctly. The 9 members of the Constitutional Court of Bosnia, 3 of them are appointed by the European Court of Human Rights, so they are international judges. And I don't say anything else because we can open a whole new discussion on the presence of international judges in constitutional courts, which is a topic for another seminars. But 3 of them are international judges. The 6 remaining judges, 2 are Serbs, 2 are Bosniaks, and 2 are Croats. The Bosniaks and Croats appointed by the Federation of Bosnia and Herzegovina, and the 2 Serbs by the Republika Srpska, by the Assembly of the Republika Srpska. So here there is this strong identity representation in the court, but it reflects also the unique features of Bosnia and Herzegovina as a federation. And finally, let me conclude with one last example, which is Ethiopia. And Ethiopia, when it comes to appointment of judges and more generally the role of courts in the Federation of Ethiopia is an exception to the rule. And it's a very fascinating and interesting example. So first of all, Ethiopia is of course a very diverse federation. Technically, it is composed of 9 states, so 9 constituent units that compose the Ethiopian Federation, but in fact, the holders, the true holders of sovereign powers in Ethiopia are the much more numerous ethno-linguistic and cultural groups which go under the name of nations, nationalities, and peoples of Ethiopia. So it is the nations, nationalities, and peoples of Ethiopia that are the real holders of sovereign powers, and who are represented, in fact, in the House of Federations, which is the Senate equivalent, as it is called in the Ethiopian Federation. Now, the Ethiopian Constitution provides for a federal Supreme Court as the highest, the apex court in the country, and it also provides how members of this federation shall be appointed. As you can see, it is the Prime Minister, the House of People Representatives, the Federal Council, Federal Judicial Administration Council, who participate and consult with the Prime Minister in appointing these judges. But when it comes to federalism-related issues and federalism-related litigations, it is the House of Federation, in other words, the Senate, with all the representatives of the nations, nationalities, and peoples that decides on federalism-related matters. So in other words, Ethiopia chose the political path instead of the judicial path, at least to solve or to settle federalism-related disputes. So it is the representatives of the nations, nationalities, and peoples who act as the court, the final court on federalism-related matters, with the assistance of a council for constitutional inquiry, so a body composed of members of the legal profession who offer the technical assistance in this sense. But Ethiopia is really an exception in the panorama of federations. So I'm almost finished, so I would like to conclude with some final observations. So as we saw from this overview of federal systems, the involvement of constituent units in judicial appointment is very limited. If it happens filtered through the Senate, and mostly it is a political process more than being a reflection of regional interests. As I was anticipating in the introduction, most courts in federal systems can actually play an important role in settling and giving the trajectory to the federation in a more centralized or decentralized way. There have been studies that have tried to classify the type of judgments that have been released by Supreme and Constitutional Courts in federal systems to determine which is the most common trajectory. And apparently, constitutional courts, Supreme Courts, they either take a very centralist direction, so they tend to favor the central government when it comes to federalism-related matters, or they are considered to be balanced in the sense that in some issues they tend to favor the constituent units, in other issues they tend to favor the central government. But there are no countries, no courts that obviously openly take a decentralist stance that favors constituent units most of the time. So the hypothesis that has been put forth by some scholars, and I cite in particular Patricia Popelier in this sense, is whether the involvement of constituent units in judicial appointment could change this status quo, this situation. Now, it is very difficult actually to give a clear answer on this question because the variables are numerous, but certainly we may think that a more active and more direct involvement of constituent units could, in fact, influence the way courts decide. But at the same time, we have to think about how difficult it would be to actually offer, even if we find a way for constituent units to participate in judicial appointment more directly, how difficult it would be to actually represent the interests of all constituent units, especially in those federal systems that have numerous constituent units. Furthermore, the trajectory in a more centralist or decentralist way that courts take may also be influenced by many other factors. First of all, the way the federation itself is structured, the way powers are divided in the federation. If the division of power is already going in a centralist way, then the court reflects in a way the structure that is in function already. How easy it is to amend the Constitution, because if the Constitution can be easily amended, there is less litigation on federalism-related issues, and so less influence for the court. Also, if we are talking about a civil law or a common law federation, so legal tradition that of course changes the way powers and decisions are made. We have to think about the fact that Supreme Court and constitutional courts, they deal with federalism-related matters, of course, but federalism-related matters are just a portion of all the litigation they have to deal with. And the other type of litigation is not really related to federalism issues. So think about all the litigation on human rights or criminal law or other areas. So federalism matters are just a portion of the decision. So I conclude by putting forth two questions if we want to maybe explore later during the discussion. We can certainly continue to debate the extent of the involvement of constituent units in judicial appointment, and I agree it is an important aspect. But what about, and this we go back to what we were discussing earlier with Professor Arbós Marin, what about better training judges who are following the judicial career, better training them in federalism-related matters. I'm sure that this occurs already in some countries, but I know it doesn't happen in many federations. So I think it's a matter also of forming the right mindset in members of the judicial profession. in building the federalism spirit or the federalism idea. And the other question that I want to put forth, and this is a path that some federations already have embraced in a more or less obvious way, following the non-judicial path to settle federalism-related disputes. So resort to negotiations or mediations or other forms of intergovernmental relations, just to avoid the centralist bias of a court. So I stop here. Sorry for taking a little bit more than the time, and thank you. And I look forward to the discussion.
30 minutes.
There was a gesture towards me to tell me that I should take over. So can I please take over? Thank you so much. Very good morning, and thank you for the invitation. As I wait for the presentation, should I? Yeah. Oh, okay. As I wait for the presentation, I'm going to tell you something very important. When I accepted to actually give this presentation, I thought, well, this is going to be easy because I already know something about the case law. And the case law will give me enough information to actually give appropriate input for anyone interested in the topic. But then I realized from the theoretical perspective and from the theoretical point of view, something what Erika already said, comparative studies on judicial politics of federal systems remain extremely rare. And then, especially if we talk about comparative studies examining constitutional courts in federal systems, that is even rarer. Comparative lawyers seem to be very much interested in, well, theory, but not very much in practical issues. I'm sorry, not very much in practical issues. So for me, trying to combine this theoretical and practical element was actually a challenge in creating actually something very coherent in this matter. Very little attention have I found relating to the fact that if we want to talk about constituent units before constitutional courts, that is when the issue actually really started, because we do discuss federalism in general, separation of powers and so on, but not necessarily subnational or constituent units. So in the beginning, I do have two disclaimers. All right. I do have two disclaimers, and that is that if I look, for example, into the transformative role that constitutional courts play when it comes to constituent units, well, it is not necessarily as transformative, equally transformative in all federal systems. Erika mentioned, for example, the US and Canada, where transformative role was quite obvious. However, when it comes to Brazil, well, that is where the impact have remained quite limited. And then on the other side, if I look into constitutional provisions, and I wrote down Ethiopia because dealing with conflicts in Ethiopia seems to be defined, but normally federal constitutions do not give us the impression that the conflict or how do we deal with conflicts is actually regulated. How do we balance, for example, autonomy, cooperation, unity, and so on? They often divide powers. They give us the indication of how powers are divided, but not necessarily the rest. So to that end, constitutional courts often have to rely on their own interpretation of how things should work. So at the beginning, and I hope I'm not going to get Erika's microphone as well at some point, but I do expect it. At some point, I also need to make a third disclaimer that I kind of focused on Belgium and Bosnia and Herzegovina as examples, quite extreme ones. But I think they are imperfect federal models because every federal model is in reality very much imperfect, but it also gives me an opportunity to give you an idea of how constitutional courts deal with differences, identity differences in particular. So starting with the constitutional courts in federal systems, well, there's a lot on this particular picture, but there are generally two different objectives for constitutional courts. So one objective is to protect legality, constitutionality, and so on, and that is something related to the hierarchy of legal acts, supremacy of legal norms, and so on. And then the other one, which we are interested in, is related to preserving federal structure, preserving federal balance, and so on. And for constituent units, that actually means that they have the opportunity maybe to protect their territorial unity. They have the opportunity to, for example, challenge federal legal acts. They have the opportunity to force even cooperation, but that is also on the other side of the spectrum. So there is a symbolical element actually in this as well, because the constituent units should have the opportunity to challenge in order to preserve their autonomy. On the other side, federal or the central level, they also can, which happened in Belgium, which I will also give the idea in a couple of minutes, courts do have the opportunity to confirm the autonomy, but more often they push for more unity, they push for more cohesion, so they go to the opposite side of the spectrum. But the key question that I'm trying to ask here is that whether constitutional courts are actually the forum for subnational units to actually challenge, discuss, and so on, or is it really the place for the federal government to actually impose what they want to impose on constituent units? And I'll give you the examples through, of course, Bosnia and Herzegovina and Belgium, as Erika already mentioned. Because in the end, subnational units should not supposed to be a constitutional furniture that just stands and pretends to be pretty, and then the federal level discusses in their name what they should supposed to do. So in Belgium, the role of the Belgian Constitutional Court, I don't have the time to go into the development of the Belgian Constitutional Court, but the Court of Arbitration, which was established after what Erika already explained, when regions and autonomies, when regions and communities came to the light, the Court of Arbitration, the basic function was to actually deal with conflicts when it comes to division of powers. But the Court of Arbitration used, for example, principles or concepts such as equality or non-discrimination to take over other types of conflicts. And that will become visible also in the case law that I will show you in a minute. Initially, especially when the court was established in 2007, the court gave a lot of freedom to subnational units. It confirmed, in many cases, the autonomy, already exclusivity that was established in terms of shared power sharing. However, at some point, it became obvious that Constitutional Court has shifted its direction, and it became a manager of intergovernmental balance. And the court started using the Article 143, which is federal loyalty, also mentioned by Erika, to actually push forward for cooperation, for balance, asking for constituent units, in this case communities and regions, to actually cooperate for the purpose of the federal balance and for the purpose of the federal cohesion. Because from the perspective of the Constitutional Court, it became too incohesive, it became too divisive, sort of to say. And so it's quite visible, for example, in this case, Brussels-Halle-Vilvoorde. This used to be an electoral unit. When I came to Belgium in 2015, I think, it was still a hot topic. This case law is from 2003. And Brussels-Halle-Vilvoorde was an electoral unit in which Dutch-speaking and French-speaking could actually vote on both lists, but also they could vote on predominantly Dutch-speaking ballots, which was perceived from one perspective, if you know anything about the electoral system in Belgium, it was perceived as Francophone imperialism on one side, but also on the Dutch-speaking side, but then on the French-speaking side, it was considered as keeping a connection with Brussels. So it was a symbolic kind of conflict. In the end, Constitutional Court employed, as I said, very creatively the question of equality, the question of non-discrimination, and said, well, this is not very asymmetrical, this is very asymmetrical solution, and this is the only electoral unit in the country that actually applies this bilinguistic approach, so it should be split. However, the court did not enforce it itself, but the court asked for the political actors to cooperate together based on the principle of federal loyalty and based on the principle of cooperation. It took politicians until 2011 to reach an agreement, and only in 2012 this electoral unit was split. But it showed that the Constitutional Court, in this particular litigation, tried to impose coordination between the units. Another interesting case is also a Flemish care insurance case. And in this case, what actually happened was that Flanders, where I live in Antwerp, Flanders at some point introduced care insurance for the elderly, but only within the Flemish region, Flemish-speaking region. And then, of course, it raised questions both by the French-speaking community, but also Walloon region, in terms of access to this type of a care. And so they challenged this. They started litigating against the Flemish region and Dutch-speaking community. And then the Constitutional Court thought, okay, maybe this is too much for us. We're going to direct this question to the European Court of Justice. And then ECJ said, well, what we think is that, okay, this is against the freedom of movement, so let's go back to the Constitutional Court. And then the Constitutional Court imposed again the principle of cooperation in solving this issue and trying to harmonize actually the legislation. So in this matter, it's not only the positioning of the subnational units litigating against each other, litigating against the federal level, for example, but it's also positioning subnational units within the broader European Union family as well, in this case, European Court of Justice. So from this perspective, I think Belgian Constitutional Court shifted its appearance towards, for example, towards the constituent units or subnational units, from being very lenient or very affirmative towards insisting on very much, insisting on a lot of cooperation, on a lot of federal loyalty, which for now works. But I'll show you also a different type of situation in Bosnia and Herzegovina when this actually tips the iceberg and then the situation becomes very, very dire. I'll move to, for example, maybe I should mention that there were, before I go to Bosnia and Herzegovina, there were two more interesting cases, telecommunications case. Just briefly, so if you have questions, you can ask during the discussion time. So in terms of telecommunications, it was also the litigation, as I said, in Belgium, everyone litigates against everyone when it comes to the division of powers and competences, because there's exclusivity, there is no supremacy clause, there's equality between the levels. So technically, everyone can litigate. So the levels can litigate between each other, against each other, and even, they can litigate against the reality of the Belgian constitutional system. So in telecommunications case, it was the Constitutional Court that actually made all of the levels, meaning federal level, but also regions, to make a cooperation agreement, actually to make an agreement about radio and TV, which means audiovisual representation, which should have been kind of harmonized for the whole Belgium. And then Klimaatzaak, which relates to climate change, which was not actually decided at the Constitutional Court level, but by the Brussels Court of Cassation, relating to the climate change issues, but where the court actually said everyone should work together, and they invoked this principle of loyal cooperation, but also the principle federal loyalty, but also the principle of cooperation. And also Bosnia and Herzegovina. Bosnia and Herzegovina, a very difficult case. As Erika already explained to some extent, I will not start with the role of the Constitutional Court, but I will actually make a conclusion of what the role of the Constitutional Court in Bosnia and Herzegovina is. Erika already explained there are two entities in Bosnia and Herzegovina. And one is the Republic of Srpska, the other one is the Federation of Bosnia and Herzegovina. Even before the Dayton Peace Agreement, the country was already split. Afterwards, the constituent peoples that were imposed, sort of to say, by the Constitution, meant that only Serbs were the constituent people in the Republic of Srpska, and in the Federation, Croats and Bosniaks were the constituent peoples. And then comes the Constituent People's decision in 2000. My former supervisor was actually a Constitutional Court judge, one of the foreign judges on the bench, Joseph Marko. And I know a lot about this case, and it's a very interesting case because in this particular case, the court said it was challenged also by the member of the presidency, yes. And so the court said, in this particular case, we do think that the constituent peoples, all of them, should be equally constituent on the whole territory of Bosnia and Herzegovina. It caused havoc on the whole territory because it meant the complete rehaul of the constitutional system. It meant a lot of constitutional amendments to both constitutions of the Republic of Srpska, but also Federation. It also meant introducing additional institutions as well. But it also meant that from this point on, Constitutional Court in Bosnia and Herzegovina took its position in order to move the system from very divisive, almost dyadic system as it insisted in Belgium, to move it towards more coherent, integrated system. However, it didn't last for that long because at some point there comes resistance to centralization. Because starting with 2019, but also entering 2021, and also in 2023, the Republic of Srpska as a constituent unit starts challenging, for example, the role of the Constitutional Court. First of all, it started with challenging the division of powers and competences that were already transferred from the entity level to the state level. So that meant that, for example, powers and competences regarding to the army, taxation, even the court of Bosnia and Herzegovina was in question. So the court here pushed back and annulled all of these decisions, which then in 2003 caused additional decisions from the leadership in the Republic of Srpska saying, well, we do not necessarily recognize or acknowledge the decisions of the Constitutional Court. And then, again, litigation before the Constitutional Court between the Republic of Srpska Federation and the state level in terms of positioning Republic of Srpska and denying, again, Republic of Srpska of this particular position. So what happened in the meantime was that because the court seemingly pushed too hard, it caused also the pushback from the from the subnational units. So from this unifying factor, which pushed a little bit too hard, created a situation in which there's a completely the opposite effect. Or maybe not. So So the role of Bosnia and Herzegovina to actually, yes, I'm almost there. So the role of the Constitutional Court of Bosnia and Herzegovina came from the constitutional integration, so trying to integrate the system as such, to provide the functionality of the system, which was very much dysfunctional as it was, towards the constitutional destabilization. Because right now, governance happens, but it happens on a very good day during 1 year. Which reminds me also of something that I often mention when I talk about federal loyalty and so on. For a very long time, when I would discuss federal loyalty in my papers, I always thought that it's a concept which can bring a certain amount of cohesion within the system. But I always thought that it was trust. And trust is not, I'm a lawyer, so trust is not necessarily a legal term. But I always thought that the trust in the fair management of the system is actually something that brings in the stability. And I often cite the distrust or mistrust of Catalonia towards the central level in Spain in terms of gaining financial autonomy, for example, similar to the Basque Country and so on. And I think this is the same situation that has happened, for example, in Bosnia and Herzegovina. And to briefly conclude, I think, well, I skipped too far, I guess. Again, well, here I am. To briefly conclude, I think there are two maybe takeaways, and that is that the effect in terms of the positioning of the subnational units can really be or can really go in different directions. Not because the subnational units do have the right to interfere or not to interfere. But I think it really depends on the position of the Constitutional Court and how Constitutional Court handles the situation. I think yesterday we talked about how, for example, the appointments, they can also affect this very much. But I think there is a difference between Bosnia and Herzegovina, which implies this quite well. Because in Belgium and Bosnia and Herzegovina, it is about federal balance. It's about keeping the federal balance as it is. But at the same time, the logic might be different because the system is completely different. So in Belgium, it's about the coexistence of this shared constitutional network that is completely divided, as you said, dyadic even. While in Bosnia and Herzegovina, it is the legitimacy of the constitutional framework itself. So it is about the litigation as the management of diversity, for example, in Belgium, while in Bosnia and Herzegovina, it is the contestation of the statehood itself. So it really matters. What direction or what type of concepts the Constitutional Court implies. So it's not really. For me, it's not really the warning for the subnational units, but it's actually the warning for the constitutional courts at the federal level on how they perceive, and maybe the training, as Erika mentioned, is very important because it seems sometimes that the judges of the Constitutional Court at the federal level do not necessarily understand the dynamic, or they do not necessarily understand how federal systems actually work in order to understand a broader transformation of the system. I think my time is up. So I'll stop here, and there are people who know how to finish the presentation. There are people who say, that's it. I'm the person who says that's it, so that's it. Thank you. I'll return this.
Thank you. Moltes gràcies per les vostres presentacions. Tenim un torn ara de preguntes, de comentaris, si voleu.
Oh, that's easy.
Bueno, va. Li donem la paraula al director. Vinga.
Gràcies. I have a question concerning the idea you have presented on training judges on federalism. I would like you clarify a bit. Is it about the law of federalism? Is it about what is besides the law, that is political culture of federalism, spirit of federalism, recognizing diversity. Could you please develop a bit?
Yeah, thank you. Thank you for your question. Well, I guess there are many ways in which we can start thinking about that. I think, and when I thought about the training of judges in courts, Supreme Courts and constitutional courts, I was thinking particularly about my country. For those of you who don't know me, I come from Italy, and so we have a regional system in place, but it seems that in making decisions, the court, and not just the court, also like the government in general, sort of forgets that we are a regional state with clear roles for regions and all that. And I think it goes also to the fact that in universities, regional law is not really taught, and we were also talking about this with Maja. If they offer courses on regionalism, they are just elective. So regionalism, regional theory or federalism theory practices and all that it goes, with what is a federal system, what is a regional system, all these broad questions are not part of the usual training of somebody who then embraces the judicial career. And so I think they are not all of them, or very few of them, are actually prepared to understand how the system works. I think this is also, I was thinking of Italy, but I think it is a problem that is similar also to other countries. So I think that, I don't know, by making certain courses in universities mandatory, or even depending also on how a judge or how a legal scholar takes the judicial career, depending on the training, on the specific training, maybe making, I don't know, these type of courses mandatory. I think it would be very useful to have also like training comparatively, just to get a sense of where your system, your own system fits into the broad. But this is perhaps too much of wishful thinking. But I think that this plays an important part in the way courts then end up deciding in one way, in a centralizing or less centralizing way. And there is also another problem that we were discussing with Maja yesterday on these broad principles like federal loyalty or other fundamental principles in federal systems. They could be subsidiarity, another good one. There is no actual agreement on what these big principles mean. And so each judge, each court ends up with their own interpretation of the principle. And so having perhaps a more like a broader knowledge of what other courts are doing or are saying on similar principles may help. I don't know, this was just some...
May I just add something, because I think this is important. Constitutional court judges, and this is related to the federal theory itself. On the benches we usually have, well, I don't know how to say it politically correct, but we have senior citizens at this point. And they're not necessarily catching up with the federal theory, which is not necessarily anymore about unitary federal and confederal systems. And for them, it's very difficult to grasp that there's a lot of gray area in between those, let alone asymmetrical systems and so on. So catching up even with those foundational issues is very, very difficult. And in conversation with judges, this really comes forward as a very difficult topic. Let alone that in many universities, including Bosnia and Herzegovina, Belgium, and so on, we're still teaching very traditional way of how we understand federal studies. And then this also translates into education, and of course, building up from there, federal loyalty principles that you mentioned, it becomes then an additional problem as well, I think.
Yeah, if I can just add one more thing. Yes, you were right in the sense that I think that federalism theory has improved and has become such a sophisticated, thank you, compared to what it was 20, 30 years ago. There is much more scholarship out there, much more comparative scholarship out there, and yeah, it has been enriched so much, and not all judges, or very few of them, are aware of all these progress and advancements that have been made.
Alguna altra pregunta?
Hi. Hi. Well, thank you very much for your interventions and for coming here to Barcelona to share your research and knowledge. I wanted to bring your attention to compare decentralized systems with unitarian or unitary systems. So how do constitutional courts, how will we compare constitutional courts in decentralized with respect to unitarian systems? And how, if you see from your perspective that there is a deep difference in interpretation from justices that sit in constitutional courts in the centralized system with respect to those who sit in unitarian systems. I mean, the hypothesis that I have in my mind is that maybe in decentralized systems, federal systems, there is a greater tendency towards having a more plastic or flexible understanding of the semantic boundaries of the Constitution. And there might be maybe a greater resort to teleological or topical interpretation of the norm. Thank you.
Mm-hmm. Yeah, go ahead.
You can go ahead.
I think you're right. As I mentioned, with the Constitutional Court in Belgium, but also with the Constitutional Court of Bosnia and Herzegovina, but also Canada, I think also Germany. Especially in Belgium, what I've seen, the court has been granted a specific set of powers and competences to deal with. And then in order to deal with obviously specific conflicts, and as I said, the Constitution does not really regulate like what happens if the conflict arise. The courts have to rely on being very creative. And that is the flexibility. They have to be creative in finding ways or the back door on how to interpret certain things. And in Belgian case, it was through interpreting concepts such as, I don't know, educational freedom, I don't know, as I mentioned, equality, maybe non-discrimination principles, and so on, in order to connect them to the existing conflict. And something similar we've also seen, for example, in Bosnia and Herzegovina, when the Constitutional Court at some point was even accused of going into the merit of something that they shouldn't supposed to have. So indeed, in decentralized systems, the courts are often constrained, but they are also very flexible in finding or creatively finding ways around the issue that they want to address. I agree. I definitely agree.
Yeah, and if I can just briefly add, I think this is actually a very interesting prism through which we could actually learn more about how constitutional courts work if we compare them with unitary states. Because I don't think that this is a type of comparison that we usually do. So, because we tend to compare decentralized systems among themselves, more or less decentralized, but within the pool of the decentralized systems. But this cross comparison with unitary states doesn't, to the best of my knowledge, doesn't happen very often, but perhaps it could be a way to actually understand better how federal courts work. So we'll keep that in mind for future projects.
Yeah. And if you want to join, of course. There will be a disclaimer otherwise.
Alguna altra pregunta? Mario?
Now, of course, since you mentioned the comparative perspective, I will also go a little bit more in detail, comparing the federal systems in between. So, of course, from our perspective, of course, we have these big two categories coming together or staying together, federal systems. And my question would be if there's a difference of how judges are appointed in these two big categories of federal systems. My idea is, of course, maybe they are very huge differences, or maybe there's a trend towards a certain homogeneity, or they are coming together, since institutions are no longer the same. So you mentioned this for the United States, the Senate, now it's quite different than the Senate, which the founding fathers had in their mind. In Germany, we have also the political systems is changing quite a lot. We have a huge amount of different coalition governments at the level. So the systems are changing. And maybe they are coming together, these two categories, or is there still a huge difference between them?
So, I should think more about that. So what I'm telling now is just some random thoughts that I can think of on the spot.
I think you should charge for this. For this, you should charge.
I'm not sure that there are many differences. So the centralized, holding together systems are the current trend, or the latest trend. The original federations were all coming together, like the US style. And so, of course, so the first comparison perhaps would be between like these older original federal systems and the newest federal systems. And to go back to what we were saying before, many judges and like the older school practitioners, also like lawyers and practitioners, they are still in that distinction. The traditional coming together federations and nothing else. But again, it's more complicated than that. But then I think that at the end of the day, yes, federations fluctuate. They change continually. Courts contribute to their change, but it's not just courts. It's the political context, the economic context, the social context. So I don't think. We could think about the role of constituent units and how it differs between these two broad categories coming together and holding together. But at the end of the day, I don't think we will be able to see a huge difference. That's my instinct answer that I would give you. But I leave it for a more like appropriate study. I don't know if
but maybe I think it's the layers. You're right, there's dynamic, federal dynamic, and Patrizia Popeli wrote about it. She wrote a book about federal dynamics. But I think if you start adding layers, it becomes very, very complicated. For example, is it a presidential or parliamentary system in the federation? And then you can add layers, and then I don't think we have to do an empirical study probably to actually make structure out of it and to organize it properly. So I don't think we can give the answer from the top of our head. Like it requires like a proper understanding.
And then like we were saying before, there are like trends in the way courts, so courts adjudicate or decide on these cases. There are like periods of like the Supreme Court of Canada. That's the classic example. It started with a court that was this Privy Council, which was based in London when Canada was still a dominion. So there wasn't a Supreme Court. There was a Supreme Court, but the apex court was this Privy Council, a British imperial institution based in London, which was interpreting federalism-related matters. And surprisingly, most of the decisions were very much favoring provinces. So during the Privy Council era, Canada became a very decentralized federation. And then at some point in the late 40s, early 50s, the Supreme Court took over, became the apex court, and it started a period of centralization in the type of decisions for no reason, apparently, other than perhaps a different political context, a social context, and so forth. So, this also adds to the challenge because, it's not a fixed, it's a changing dynamic all the time, which makes empirical studies difficult.
Difficult, but also I think that it can explain, for example, congruent features, why something happens in the way it happens. Like why, for example, the Constitutional Court of Canada took a middle ground in Quebec referendum, for example. Law is very contextual. And I think we can explain the context if we take into consideration, I don't know, political, economic, whatever context, separatist claims, I don't know. There is a way how we can do it, but I don't think we have the means at this point. Like we need a project and funding.
We need funding.
Okay.
Alguna pregunta més o ja podem concloure? No sé.
Speak now or remain,
or while you're having coffee.
Or, yes.
Right? Ok. Doncs moltes gràcies. Tenim ara una pausa de 20 minutets i tornem. I wanted to ask you about the final table comparison, because all the